Applications for administration by creditors. Conflicts of interest. The estate of Dean John Edmonds, 2025 New South Wales Supreme Court 223, decided on the 18th of March, 2025 by Justice Slattery. This case involved an application made by the deceased's mother, who was the plaintiff, for letters of administration in her capacity as a creditor of the estate. Here are the facts. The deceased died intestate. He had been married twice before, but at the time of his death he was divorced and had 4 children, who are considered the deceased's children or next of kin. Although the deceased's children were entitled to apply for administration, they actually had no interest in making an application. In fact, there was correspondence from the solicitors for the deceased's children in 2021 advising that the children would not be making an application and that they were prepared to sign the necessary consents to allow the plaintiff to apply for administration. The deceased's estate was valued at approximately $250,000, comprising a half-share interest as tenants in common in 2 real estate properties in Oakland. One property was a half interest in the Oakland's hotel, owned together with the deceased's brother, and the other was a half interest in a residential property, owned with the plaintiff's partner. After the plaintiff applied for letters of administration as creditor of the estate, the court issued a number of requisitions, requiring that sufficient notice of the proceedings be provided to the deceased's children. Now, the attempts made by the plaintiff to locate and correspond with the deceased's children actually caused delays to the administration of the estate. In fact, only one of the deceased's children could be communicated with by email. The plaintiff applied under Section 14 of the Civil Procedure Act 2005 New South Wales for orders to dispense with the requirement for notice of the plaintiff's application for administration to be given to the next of kin under Rule 64 of the Supreme Court Rules, 1970, New South Wales. The issues before the court were, firstly, whether letters of administration should be granted to the plaintiff, notwithstanding her position of conflict as a creditor of the estate, and secondly, the degree of surveillance required to protect the interests of the next of kin in the estate, given the conflict. The court recognised that, in applying for administration under Section 63 of the Probate and Administration Act 1898 New South Wales, preference is to be given to a spouse or next of kin of the deceased before a creditor of the deceased's estate. The court held that an application made by a creditor is generally weaker because of the conflict of duty that arises where an administrator needs to act on behalf of the beneficiaries to preserve the estate, whereas a creditor brings claims against the estate to recover the full amount of their debt. Notwithstanding the conflict of a creditor being appointed as administrator, the court considered that the estate was not large enough to appoint an independent administrator who would be entitled to charge professional fees and remuneration. The court granted letters of administration to the plaintiff under Section 74 of the Probate and Administration Act 1898 New South Wales, because no one else was willing to undertake the estate's administration. However, the grant was made subject to conditions. Firstly, any distribution of the estate would require the consent of the next of kin or approval of the court. Secondly, the next of kin must be kept informed of the progress of the estate's administration at least every 2 months. Thirdly, any payment of a claim against the estate requires 21 days' notice being provided to the next of kin with full details of the claim and reasons for payment to be made. This case, really highlights the importance of a legal personal representative protecting the interests of beneficiaries to an estate. For any assistance, please contact MJM Lawyers, your trusted New South Wales wills and estate lawyers led by our founder Michaela Money, who became a solicitor in 1998 and has been an accredited specialist in wills and estates since 2009. Visit www.mjmlawyers.com.au to book an appointment or call +610 280 893139. With a wealth of experience, Michaela Money and the team are here to guide you with confidence. Liability limited by a scheme approved under professional standards legislation. Disclaimer. This post contains information of a general nature only and is not intended to be used as advice in relation to a specific matter. Although every care has been taken in preparing the document, it may not be accurate or complete, particularly in the context of specific circumstances. MJM Lawyers disclaims responsibility for any errors or omissions.